Continuing our conversation on influencers using artificial intelligence, there's a brand new feature inside of Photoshop called Generative Fill AI. We've had an episode about this that you definitely want to check out, where everybody's favorite IP and entertainment lawyer is breaking down how this looks from a copyright perspective. But now let's talk about how this impacts influencers who want to use this to extend the backgrounds of the images that they're creating for brands. Does this have implications on the brand deals that we're going to get in the future? Let's talk to everybody's favorite lawyer to find out.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
Let's talk generative fill AI, where a program like Photoshop will allow you to input a piece of content and expand it with generative fill. For example, an influencer could potentially take a really great photo, but they need it to be bigger on the top, on the side, on the bottom. And so they use generative fill to expand that image, and they don't do it by hand. But we know from having conversations with you, Tony, that this could potentially affect our copyright. So how does this impact influencers who want to use this on imagery for their website, for their social media, and most importantly, for the branded content they're creating for companies?
So there's a lot to it, but I think the main question that we want to ask is the end product that we're seeking to create something that we want to receive copyright protection for? Because at the end of the day, if we're just sort of, adding some imagery to our website just for the sake of filling it out, and we really don't want to necessarily go through the length of registering that aspect of it with the Copyright Office, I think at that point, I think it's okay. But we have to have this honest discussion about copyright if you have the intent of actually registering that work in the US Copyright Office. And we spent a lot of time talking about this in previous videos, but the core of it is that essentially the Copyright Office has taken a very firm stance on anything generated using artificial intelligence. They've been extremely emphatic in stating that anything that is created using generative AI will not get copyright protection. Why? According to them, human authorship is an essential element to any work of authorship, whether we're talking about artwork, sculptures, film, television shows, photography, choreography, anything of that sort, anything that is deemed a work of authorship under the Copyright Act of 1976. And so if you want to register a copyrighted work or even to create a copyrighted work, it requires, according to the Copyright Office, substantial human involvement. And that kind of makes sense, especially if you were to boil it down to the philosophical understanding of copyright law. You have an idea for something, it's in your head, but it's your idea that's in your mind that you then materialize in some fashion. You express it by way of artwork, sculptures, photography, film, whatever it is. That's the idea expression dichotomy that I think in some way is almost lacking with artificial intelligence. But all that to say, that's been the stance from the Copyright Office, and they've been very firm on it. They've made plenty of their own in-house decisions on this point, and we've had the iconic DC Circuit decision that just went down, the Perlmutter case, Thaler versus Perlmutter, where essentially the DC District Court said that anything generated using artificial intelligence will not get copyright protection, and basically the court reaffirms the Copyright Office's stance of human authorship. So all that to say, if you're an influencer and let's say you're working with a brand and let's say you had an obligation to create photography to promote a brand or something, promote a product, and you use generative AI fill to, let's say, fill out the edges of the photo that maybe you couldn't really capture at that moment when you were grabbing that photo, or maybe even grabbing video, that's where you really need to ask yourself, is the brand, well, first you want to ask yourself, who's going to be the end copyright owner of this asset? Because that also boils down to what the influencer agreement says between you and the brand. If whatever you're creating is going to be deemed a work for hire for the brand, then obviously it sounds like the brand would be the copyright owner. However, if you're working in such a fashion that you're still promoting the brand, but you will still be the copyright owner of that work of authorship, then you're going to be the copyright owner. And once you know, or at least identify who the copyright owner is for the assets related to a brand campaign, then the next question is said copyright owner going to want to take measures to register that work in the US Copyright Office? And if the answer is yes, then that's when we get to the heart of this, which is, would it even get copyright protection? And I think that that's really the unknown at this point in time. We really do not have the best answers about the threshold of substantial human involvement. We don't know what the sliding scale looks like. We don't know if you need to have at least 50% of human authorship in order to get copyright protection. We don't know if that's more. We don't know if that's less. We also don't have any guidance whatsoever about whether or not the Copyright Office would do kind of like an all or nothing at all approach with copyright registrations that invoke the use of artificial intelligence. So, for example, there was a decision from a few months ago with Zarya of the Dawn, the graphic novel, that employs the use of generative AI that was created, or rather artwork that was created using Midjourney, a generative AI platform. The Copyright Office did not grant protection to Krish Casanova, the author, because even though they went in and used Photoshop to touch up the AI generated images, the Copyright Office said that image is not generated using substantial human involvement. However, the Copyright Office was willing to grant protection to the text, to the dialogue, to the other aspects that were authored by Krish Casanova. So the question then in this circumstance is, would the Copyright Office kind of take a similar stance here? Would they say, well, the stuff that was filled in with generative AI won't get the copyright protection, but everything else will? Then, at that point, you're just better off registering the photo itself and not even worrying about the generative AI fill version of that same photo. So a lot of ifs in this scenario. There really isn't like the best roadmap or guidance at this point in time. But that said, I think that knowing where we are right now with generative AI, it's very early on. And I think that we're going to have a better sense of the landscape of generative AI come maybe even months, or, well, I would say weeks. For maybe I'm being a bit liberal there, but certainly in the coming months, maybe even years for sure, we'll have better guidance about where does generative AI fall within the realm of copyright law. And that's going to come with a lot of great case law that is bound to happen. The Open AI case with all those authors, including George R. Martin, is probably going to be one of the most important AI cases that we're going to see boil down. The Thaler case, I'm sure, is going to go on appeal. That has a potential of going all the way to the Supreme Court. And if it does, groundbreaking in its own right. There's just a lot of great, exciting case law happening at this point in time. And that's going to help create the roadmap of where AI falls in the copyright space.
And of course, we are going to be bringing you breaking news as more of these court cases roll out. But Tony, let's say we are influencers working with different companies. I would suggest to them that you are not using generative fill AI to do anything with the content you are handing a company unless you have a conversation with them in advance. You need to have a conversation about what is acceptable for them, what they are willing to take, what they want to do with it, if they want to copyright it. You need to have all those conversations. So with that in mind, is it important to have that conversation and then get that information in the contract before signing on with them, Tony?
I actually am so glad you mentioned that, and I couldn't agree more. I think that that is an imperative conversation that every influencer needs to have with a brand, and I think that boils down to a lot of reasons. One, would using generative AI be no different than staging or sort of maybe faking a product review? That boils down to the ethics and the standards and practices that come with doing product reviews, and maybe using generative AI perhaps goes against the brand identity or the integrity that the product is trying to promote or evoke in terms of, I guess, getting consumers to buy in on it. So that's one concern. But two, when you look at some license agreements, whether you're talking about, the license of a copyrighted asset or trademark rights, or even in other standard license agreements like what exists between an influencer and a brand, one of the core clauses that you commonly see in a representation and warranty clause, which is one of the many voluminous clauses that exist in these types of agreements. One of those little sub clauses under the rep and warranty clause would basically say something to the effect of that the influencer has not done anything to necessarily harm the integrity of the product, or at least stage any aspect of the use of the product, and essentially, what it's trying to boil down to language wise is say that you're not doing anything that is unethical, that you haven't staged anything, but that your honest review, or however you're using the product, is honest and truthful. Now, obviously, there are brands that pay people for the good reviews, so that gets to the another aspect of integrity and ethics in the influencer space.
Mhm.
But the goal is that if you're going to present a product, and if you're being paid to present that product in an honest manner, you're going to do right by the brand. So if you are going to use generative AI, I think that does boil down to some conversations that you do need to have with the business development manager that you're talking to at the brand, or the PR person that you're talking to, whoever it is that you're talking to at the brand. You may just want to vet it with them, because you don't want to do something that could either endanger the terms of the deal or maybe even cause a breach of contract claim that could actually create a null and void scenario and and then cost you a payday with that brand. That
Right.
is actually the worst thing that you could ever ask for. So
Yeah.
obviously, talking to the person that you've been communicating with the brand, and maybe even talking to a lawyer would be a
Yeah.
very honest and conscious way of approaching the use of AI if you were to ever use some aspect of it in brand promotion for a product.
And I always recommend that you do have a lawyer helping you go through the contracts. I know Tony does as well, because we are not skilled in the law, and a lawyer is. They are the only person who is fully on our team to make sure that we are taken care of legally and financially. So make sure you have yourself a lawyer, especially if they're adding clauses or changing things or it's different than what you are typically seeing. Have someone who is professional go over it just to make sure that you truly are taken care of in whatever contracts you are signing before you sign them, because you could find yourself in some really sticky situations if you do not. If you have questions as an influencer on using AI inside of your business, we have an entire playlist on the legal, ethical, and creative side of entrepreneurship and AI. Tony's in a ton of episodes on the legal side. We will link that down below, but we're also adding episodes to this almost every single week. So if you've got questions on using AI as an influencer and the legal side of things, questions, go ahead and drop those for us down below. We'll get those answered in upcoming episodes. And as always, if you don't want to wait for us to get to those episodes, or you just feel like hanging out with Tony because he's so awesome, Tony, where can everybody find you online?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Follow on for daily episodes helping you navigate the world of your social media marketing to make this your most profitable year ever inside of your influencer platforms. If you have questions, drop those down below. Tony's coming back for upcoming episodes. But my goal here is to make sure that we are keeping you legally protected and giving you the tools and resources and knowledge so that you can create luxury time in your business, so that you can thrive as a professional influencer but have lots of time to live your best life because your business is working on your behalf and you don't have to be hands-on every minute of every day. We'll see you in the upcoming episodes.